Hi and welcome. Welcome to our webinar today. I'm so glad that you're here. Today's webinar is going to be about how to leave money to your kids. What to do first. If you want to leave an inheritance to your children, which is the way that you think is best? And we're going to talk about some myths, some mistakes, and the right way to do it as well. So, the title of our webinar today is Before You Leave Money to Your Kids, before you leave an inheritance, before you start doing these things yourself, then do this first. Do these essential estate planning options, perhaps, or at least know about them. And that's what we're going to be talking about today. And also, I want to point you to a link that you're going to be seeing on this description. There's a link about scheduling a phone call to inquire about your own personal situation because this presentation is for educational purposes only. So, not for legal advice as to your specific situation, and there's no attorney client relationship, which is considered legal advice when you meet with an attorney. And this is not that. This is for you to know what steps you may want to consider if you want to leave money to your kids. So you might be thinking, perhaps a will is the best way to do it. You may already have a will. Although I will tell you that 70%, at least 70% nationwide of people have no estate planning at all. They don't even have a will. So there's not even a guidance for the court. And what that means is that the laws of the state, the government writes your will for you, right? So it's called laws of intestacy. So, unfortunately, when you either have a will or you don't have a will, this could result in costly mistakes, frozen accounts, family disputes, lost assets. And that's something that can be avoided. We're going to be talking about that today. First, let me introduce myself. I'm Elena Ortega-Tauler. I'm an attorney for over 20 years here in the state of Florida, and I'm also the founder of Legacy Trust Council. So I have seen throughout my over 25 years experience many families both help them secure their legacy, but also I have seen some consequences of not doing any planning. And this is really one of the motivations that has inspired me to create this law firm, to create Legacy Trust Council. And I'm also a mother. I'm a mother of six. So I know how it feels worrying about protecting your children's future. My kids are the main inspiration for the work that I do. And so that's one of the motivations also that's led me to help you protect your children, your assets. I also want to tell you about Raquel Tomas, who's an attorney with our law firm as well. And she also specializes in Medicaid planning. She's also dedicated to guiding clients through the complex process of estate planning, um, asset protection, um, planning not just for your family, but also for your business. She's also my daughter. So this firm is a business that is a family business. Many of you I know have family businesses, small family businesses where your family is also involved. And it's really, really important to make your family business or even just your business part of your estate plan because you want to make sure that your business is taken care of and that it doesn't die when you die. Also, if you could not take care of your business, who would step in? Those are things that are also part of estate planning, right? So together we have helped in this firm provide asset protection, helped countless families plan for their future and receive the peace of mind that they're looking for. So I want to welcome you to our firm. But before we dive in, I have two questions for you regarding this webinar. So I want you to consider, I want you to tell me, you can email us or even in a phone call, let us know if you have minor children or adult children or both, because it is a little different. It is a little different if you're planning for minors or if you're planning for adult children, right? This is crucial, and we're going to be talking about that and explain to you why and what the consequences are also if you have minor children of not planning for them in the event that something happens unexpectedly. You don't make it home tonight. What would happen to your children? Do you have a process put in place? We'll talk about that as well. So, for the next 30 minutes or so, we're going to be covering some information that will hopefully encourage you to take action and protect your family. Not just learn, but put it into action. So, and here's why planning for minors is different from planning for adult children. So, when you plan for minor children, you need to take into consideration legal guardians, like pre naming who would step in either temporarily or for the long term if you would not be able to raise your kids because something unexpected happens, right? So you get to let the court know who you would want to step in, or you can put documents in place already naming those people, right? And these are people you trust and you know that will raise your kids or even take care of your kids the police showing up to your house, taking the kids to protected services, and putting them in the hands of strangers, even for a minute. You wouldn't want that, much less for days, right? Until the proper person can step in. Well, these are concerns when you have minor children, and this is something that we guide you through and we help you. We also consider if some of your kids have special needs, and we can put a plan in place for that as well for them. Also, if you have minor children and, for example, you have a life insurance policy, well, they cannot inherit anything. They cannot even receive from a life insurance company money, right? Because they're minors. So they would not be paid to them. But the court then would have to look for somebody, name somebody to a guardian of the property and of the kids. And this can be costly. This can deplete your assets that would normally just go to them and then have to pay attorney's fees, guardianship fees, and a lot of other fees that would be unnecessary. So you could also, for minor children, name or design the distribution, what ages you would want them to receive the money, even from a life insurance policy. You wouldn't want them at 18 to get all the money, right? Because they may not know how to manage it. And this is something that the court would do. They turn 18 and the court would just give them the money. And I know that at 18, I would have probably myself even not been able to manage a lump sum of money. So if you're no longer here, who would manage that money for them? These are all the concerns that you have for your minor children. You could also have some of these concerns for adult children. Even if they're adult, you can build into your inheritance like asset protection, right? To help them protect what you leave them from third parties, from a future divorce, a lawsuit, things like that. So, asset protection is so very important. We find with the families that we've worked for and that consult us that this is very important to them. They want to make sure that it's for their children, their heirs, and not for, third parties, or even someone that may take advantage of them knowing that they're going to be receiving a lump sum or a large inheritance, right? So these are the concerns that we go over with our in our consultation, and we'll talk about that a little bit more. So, what are the mistakes that people make when leaving money to their kids? Well, we mentioned already a couple of them, like, for example, a will, a simple will. A simple will does not um, transfer any assets. It would have to be filed in court. That's the definition, actually, of a will. It needs to be proved, it needs to be probated, right? And this is what the court is called, probate court. So you want to make sure that you're leaving your children the assets that you have for them with a book of instructions. You want to make sure that they get it the way that you want, when you want. A will is not going to do that. Okay. Another mistake and another option that people do, like a do it yourself kind of thing, is that they add their kids to their bank accounts, or they add their kids to their property, to the real property. And again, this is a risk also. It means that now the money is at risk from, if they go through a divorce. In fact, we have an example of a case study of that exact thing happening, right? So you don't want to name your kids on your bank accounts, and it's not the way to leave money to them, because that money would be at risk. Number one. Number two, it may end up hurting them in a way because they're responsible for that money, and they're deemed to be owners. It's an asset that they're already entitled, to receive. So those are the mistakes and the common mistakes that we see. Um, Failing to plan is really failing to protect your children. That's what the reason we're here today to talk about that. The case study of John that I mentioned. So, John had two grown children. He added them to his bank account. The bank account had about $500,000 in it, which is a substantial amount. John, it ended up sadly that unexpectedly he passed away. His kids were already named in the bank account as the beneficiary. So while this happened, the bank froze the account just to get legal verification, and it prevented immediate access to the two kids. One of the children ended up being part of a lawsuit while this was happening, and the creditors attempted to claim part of the money in the account, or half of the money that was in the account for this one child. Simultaneously, the other child was going through a divorce, and his ex spouse sought to claim a share of the inheritance. And due to these complications, there had to be attorneys hired, legal fees, a battle between the creditors and the creditor claims, and this depleted the assets, leaving the kids practically with nothing. This is an example of unintended consequences of adding your kids to a bank account, and it's something that happens all too often. So, what is the also the risk of transfer without a plan? Well, if you just add or name your kids in your will, then probate may be tied up for months, even years. In Florida, some counties can take between 9 months to 2 years. And this is in cases where it's not complicated by claim, by creditors and lawsuits and things like that. In addition, legal disputes come up between relatives. People want to know if they're entitled to something. And this is something that can be avoided. So Probate is a consequence of having not a complete plan, of having a will thinking that that's going to be enough. And we see that all the time. So, family conflict is also very sad. I see it sometimes just break up families. In addition, and also the biggest thing probably is that there's no asset protection. Once your heirs receive the money that you have for them, it's distributed by the court to them without asset protection. You can build asset protection into your plan with a trust, for example, and we'll talk about what that is next. So, why leave money to your kids um, through a plan in the first place? Well, we mentioned some things. We avoid probate, court delays, court costs. Um, the probate process is estimated to take between 5% and 10% of your estate. This is money that is lost, money that you pay for a lawsuit that really you can avoid. So it's a lawsuit you file against yourself because it's with your money, and it's not for the benefit of your kids. So there will be legal fees, court fees, bond premiums, filing fees, appraisal fees, you name it, etc. And that can add up to a lot of money. It also having a complete plan that avoids probate, it can prevent frozen accounts. Your children can receive what you decide when you decide, no matter how old they are and no matter when this takes place. So it is a plan that you put in place now, but it can be for your future and your kids' future, no matter when that happens. It also minimizes the possibility of tax burdens and costs. Um, and this is something that we discuss on a one-to-one basis because every case is different. So we talk about probate and what is probate and why should you avoid it. So, like I said, probate is a court process, and it's a court process that if you die with assets under your name, whether it's a small bank account, whether it's a house, whether it's a business, any money, investments, whatever it is, even personal property, you die with all of this under your name, and the court has to decide in a probate court case, and this is something that can be avoided, right? So there are delays, costs, lack of privacy, complications, disputes. Meanwhile, assets are frozen. Your family is not able to access them, even if renewing leases, if you have investment property, things like that. It requires the authority of the court, and the court has to sign off on it. So be very careful with that because that can put your family at risk. Fortunately, fortunately, there are solutions to bypass the probate entirely, such as using trust. Let's talk about trust. What is a trust? Well, to begin with, it is an alternative to a will. So instead of having a will or a probate process with all the things that I talked about, there's an alternative, and it's called creating a complete, comprehensive estate plan. And if you have assets under your own name, then avoiding the probate process, putting it in your trust. So, the use of a trust. A trust allows you to set specific conditions. It's like your book of instructions, right? So you decide, not the law, the courts, and so forth. It's you who decide. Of course, it has to comply with the laws, and this is why you need legal advice and to know how things are, how they're affected by the law, and what your options are. So this is a way that to make sure that your children receive their inheritance the way that you want when you want. And like I said, it could include milestones like ages, stages, educations. You can say, this is the way I want it, but first my trustee, my successor trustee, has to make sure that these other things are complied with. And those are your laws, those are your rules and your instructions, right? So your trust can protect your children even if they're going through a divorce, if they're going through psychological problems, and it would be a mistake for them to get assets right now because they need treatment, they need to know, they need to be cared for, they need to know how to handle it. And this is something that perhaps is not even known right now, but if it becomes a reality in your family, then already your instructions are going to take care of them. So it's almost like you can foresee or prevent something in the future from happening by taking action while you're alive and well, right? So, trust can also help you manage your business. Like, who's going to be the person handling your business, and how is your business going to be handled if you suddenly couldn't, for example, or if you are no longer here, then how would that business continue to take care of your family? Things that we can put into your estate plan. So we can also, through this plan and through this trust, we can also provide bulletproof asset protection against third parties, against ex spouses, lawsuits, bankruptcies, even family disputes, right? So these are the solutions of a trust. And let's talk about briefly, at least, what a trust is or how it's set up, even. What kind of trust? So there are many kinds of trust. And when we advise clients, we first have to know their situation, their assets, their goals, their family structure. And there are revocable living trust, which is a trust that we use quite often for our clients because it is very flexible. It's like you still manage everything. In fact, you do. You play the role that you play now. You go to the bank just like you would go right now. Take money out, put money in, close a bank account. You have the power, right? So you can sell assets, you can sell the house, you can mortgage it, even though that all of this is going to be titled to your trust. And the reason we're titling it to your trust is because, like I said before, if you die with things titled to your name, it goes where? I hope by now you know that it would go to court. It would be a lawsuit. It would be a probate court, right? So the revocable living trust resolves this while still keeping you in control. So you play the three roles. You're the grantor because it's your stuff, right? You're putting it into your trust. You're also the trustee because you're going to be managing like you do now. And you're also the beneficiary because you can sell it, give it away, mortgage it, do whatever you want, right? So the revocable living trust is a really good option for a lot of people because you set it up while you can, right? You take action now and you set it up, but it does not affect you. Even your home, you would still have homestead um, exemption. You would still have, the home title to you as the trustee if you're the trustee now, but under the name of the trust. So even if you have a mortgage, a lot of people ask me this question: what if I have a mortgage? I haven't finished paying for the house. It does not affect that. It is meant for inheritance purposes. And it has nothing to do with the mortgage. You're still responsible to pay the bank the mortgage, and the bank will not cancel the mortgage or say, hey, you shouldn't change title. This is an exception to that. Okay. And we can discuss that on a call. There's also irrevocable trust, and those are on specific situations and depending on the assets and the goals. We discuss those if they apply to you. And there's special needs trust if you have a child that may need protection, and there's a way to do it through a special needs trust or other planning in your trust. So how a trust is set up is like it's your treasure chest. Like your everything is in your briefcase, in a treasure chest, and in your red wagon when you had your toys as a child. So you will be pulling it and keeping everything with you. But when you no longer can take care of them, or you're no longer here, either way, it's passed on to the next manager or trustee. It's called the successor trustee of your trust. So if you have any questions about that, we can set up a call and discuss it and decide whether you can decide after you get all the information if this is right for you. So a trust is not just a trust alone, but what we put together for our client, because a complete estate plan, the way we see it, is a comprehensive plan. It's a complete and comprehensive plan. It takes into it takes into consideration your health, like healthcare directives. So, what's a healthcare directive? Well, this is a document where you will name a healthcare agent to make medical decisions on your behalf according to your wishes, right? If you become unable to do so yourself. So it allows you to express your wishes regarding your medical treatment if you can't do it yourself. And some key aspects of a healthcare directive in Florida is that you can designate a healthcare agent. This is someone you trust. And by the way, it could be several people in case someone couldn't act or wasn't available. Because remember, this is for the future, right? So, someone that can be your agent, this person will have the authority to make healthcare decisions for you if you're incapacitated. If you can name, you can also name an alternate agent, and this person would have the authority if that first named person couldn't act. So your agent also can medical records, can consent or refuse certain treatment according to your wishes. And you need to communicate with this person in your family so that they know to make sure that your wishes are honored. They know what you want, right? They can get your medical records because otherwise, sometimes you would need the court to authorize your family and even sometimes your spouse to act for you. So this is something that people sometimes not aware that just because they're married, that doesn't mean your spouse can take action immediately for you. So we also put together a living will, and this works in conjunction with your healthcare directive, right? So in cases where there's a conflict between your living will and your healthcare directive, the provisions of your living will generally prevail, right? And this is how you would want your end of life decisions to be made. You don't want to be put in an intubate. You don't want to be intubated in certain circumstances. But remember, there were circumstances where intubation was necessary during the pandemic. So you want to make sure that you have comprehensive documents that take care of every situation for you. So you also will have with us a pour over will. It's like a last will and testament, but it's like a backup. It's a safety net, right? It is a document that works in conjunction with your trust. In the event that an asset was left out, or was not known or did not exist and is now under your name. So, to avoid going through the probate process, this document will ensure that it gets included and distributed according to your wishes, right? As part of your trust. So you also have a durable power of attorney. This is so necessary. This appoints someone, and actually the same, several people that can take care of your finances if one couldn't. Like, who would be the first one? Who would be the second person? A backup to take care of your decisions, your financial decisions, your business, to take care of your um, what you need to do on a daily basis, pretty much. If you have a durable power of attorney that is well drafted, even banking decisions can be taken care of by the person you appoint. Okay. And this is what we mean mean by a comprehensive, complete estate plan. Is what we're talking about. So let's talk about how to put this in place, right? How to take care of this? Well, our process in our office starts with a call. It's a simple call. It's a 15-minute phone call with either me or Raquel, the other attorney with me in the office. And we talk about how things are now, what your concerns are, what the law or the risks would be. And then um, we tell you a little bit about our process. If you decide to go ahead and schedule a full consultation, which is also complimentary, by the way, then we go ahead and schedule that consultation. It could be through Zoom, it could be in person in our office or one of our offices. Um, so we meet with you and we discuss your goals, we discuss how your legacy can best be preserved, how it can protect you and your family and provide the peace of mind that you need. So when we have that planning session, then about 4 weeks later is when we have the signing. When we have the signing is when you come in and we go over everything, we notarize, we sign all the documents, and then we schedule your binder delivery date, which is also an opportunity, if you wish, for you to leave recorded messages for generations to come, for your kids to know why you put this plan in place and what you want to accomplish and what you want them to know and to accomplish. So this way your legacy is preserved and it can be taken care of between 4 to 6 weeks. It's all made very simple because the way we have it is that nothing falls through the cracks, right? It's scheduled automatically 4 weeks from the time that we meet, and that's the delivery. And then about 2 weeks later is when we meet with you to just finalize. But that's not the end, right? We still represent you. We are your attorneys for life. This is relationship based. So future calls, consultations are all complimentary. They're included in the legal representation. So no matter what life throws your way, we are here and you can call us and talk about it. And then we can guide you through that process, whatever it may be in the future. And that's really what sets us apart from other law firms, right? So it starts with a discovery call, like I said. You can book that now. And then we determine if we're a good fit, if you feel comfortable setting up the consultation with us. And we will recommend strategies for you, and we will identify what's more important or most important for you to give you the results you want. But you will decide if you want to proceed. So then we will take it the next step after that. And like I said, our experience, your experience with us will be different because we're not hourly fee based. We're really flat fee based. We give you a flat fee according to your wishes. We also have startup plans, but we can take it from there. And we give you the access to our office really for your lifetime, right? Where you can call us and we can make sure that if you have any questions, any issues, we're here for you. So we are different in that we are relationship based. We focus on long term relationships. And if you've seen um, our testimonials on our reviews, you will see that this is what people rave about, that they feel comfortable, that they've been taken care of. So it starts with the family planning session. After the phone call, we map out and we align your wishes with and your needs with your assets in your family structure. And we personalize a plan for you that fits your needs and what you want to accomplish. And we start by getting a detailed inventory of all your assets to make sure that nothing is left out, right? And then we schedule the signing date after that if you decide to move forward. So, this is what we call the legacy planning process. And it will give you the results, the peace of mind, a plan that works to protect your children and your assets, and to make sure that your assets go to your kids the right way. So, our promise to you is really simple. We provide peace of mind with a comprehensive strategy. Our firm protects your legacy while you continue to build it. Unlike other firms, we offer transparent prices and, like I said, lifetime partnership in the planning process. So, like I said, also on the signing date, that is so important. That's a celebration. You've done a lot of work by then, and then you sign your estate planning documents. And later, you will receive physical and electronic copies. We will have notaries for you and witnesses to make sure that everything goes smoothly. So, you can book a discovery call now. Um, And I want you to know this, and this actually I'm borrowing from Elon Musk. He says knowledge is only useful if you put it into action. I think he should know a thing or two about that, right? Because if you don't put knowledge into action, it's really a waste. So I don't want you to just absorb the information you received today. I want you to use it because action is where the magic happens, where everything is done, and where you will get the results that you need, no matter what life throws your way. So you can book a call either by visiting us at our website, going to the link. You can also call us at 305 514 0608 and schedule that call. But I have a gift for you. You will receive $250 from your estate plan by just mentioning that you watched this webinar. And that helps me too because I know you're no, I know that you've been educated, right? But also, I want to inform you that there are only four, actually, I think there's only one family legacy planning session left in February, but there's still four left in March, right? Because February is almost the end of February right now. So we typically only have a few family. We're a small firm and we really take care of our clients on a personal level. So we usually have about eight a month and they go pretty quickly. So book your call, don't wait, and put this knowledge into action. And here's our contact information. I do want to thank you for attending this webinar. And I hope that if you have any questions, you can email us. You can email me personally at Elena at legacytrustcouncil.com. You can also call the office, and you can also ask for my direct email or set up a call with me. And our assistant will be happy to set you up with a call if you cannot get the link here. So thank you so much. And it was great seeing you. And I hope to see you on the inside.